I don't think there is a family law attorney who practices who will tell you that the Domestic Violence Prevention Act has not been weaponized. So there is a caveat within the Domestic Violence Prevention Act. And really the concept of it was simple. It's that we wanted to recognize that women, and that's how it started, right?
Yeah.
That there are different types of abuse. You don't just have to have a black eye. Okay, there are various definitions. There's financial abuse, there's coercive control. And what people are not recognizing, and I'm hoping that does come to light, is that withholding children from parents who want to be involved and using the litigation process to smother the other parent so that you get more support and generally the woman and the man gets less custody, that is also domestic violence. But the Domestic Violence Prevention Act has this small caveat that says that if a parent is found to be perpetrator of domestic violence, which, by the way, could also mean disturbing somebody's peace. You sent a few too many text messages one day.
Yeah.
Okay?
During that divorce process.
Yes, and that emotionally impacted somebody. So now you're a perpetrator of domestic violence. You are on the same level as the guy who gave his wife $100 a month to shop at the grocery store, and she had 5 kids, and then he would leave periodically and turn off the utilities so that she knew her place. So now you, who sent too many text messages during an emotional process, are a perpetrator like that person. And so now there is a presumption under Family Code Section 3044 that says that you can't have legal custody.
Right.
You've got to do all these different things or you can't get legal custody.
So I think there's definitely people that abuse that definition of domestic violence. We know someone that unfortunately went through that as, I guess, the victim of being called a perpetrator for the purpose of child custody.
Weaponizing it.
But I think for the audience members that really are getting beat up or psychologically tortured and all that stuff, like what are their options? They're terrified. What do they do from a legal perspective, I guess?
And so that is the hardest question, because the clients, when they come to me and I'm defending them, I tell them, like, listen, they hand these out like candy. We can do our best, but know that it could be coming. And when you have the victim, I tell them, yes, they hand them out like candy, but yours is nuanced. And I get these nuanced restraining orders where my client will tell me, I'm terrified. Like, I don't want to bring this restraining order because it's going to antagonize the person.
Right. Yeah.
And I tell people, remember, it's just a piece of paper. It doesn't protect you.
Yeah, unfortunately, people have still, been killed, with those in place. And
all it does is maybe gets the cops to you faster. And so you actually have to think, and there's also a concept of, yes, maybe somebody engaged in very specific behaviors at various points in your relationship. A finding of domestic violence, the purpose of it is for a restraining order. Do you need this person to be legally restrained from, coming within, 50 yards of you or whatever? Do you need that? Because when people start to think of it that way, they're like, no, I don't really need that. But they used to do these things. That is horrific. But do you need this litigation process? And you need to find a lawyer who understands that nuance. So for you to actually understand, do you need to go through this process?